showing the moment that an ICE agent fired his weapon in what ICE says was self-defense. For more on that, let's bring in Carrie Irvine.
Thank you for joining us today on another special segment of Inside Trial Minds, where we take a deep dive into the Minnesota ICE shooting with a civil rights attorney. Today's guest, Christian Contreras. Christian, how are you doing today?
I'm doing great. Thank you for having me.
Let me just ask right off the top, what is your perspective on the situation, given your expertise as a civil rights attorney?
My position is that the killing of Renee Good is a murder. This is a case where an ICE officer was shooting at a moving vehicle, and particularly what is most telling for me that this is a murder are the second and third shots shot by this officer. He was shooting as he was no longer in the path of the vehicle. And in fact, it's debatable whether the first shot was shot when he was in the path of the vehicle, but he was unequivocally, without a doubt, not in the path of the vehicle during those second and third shots. The vehicle was actually driving away when he shot those shots. And so, why was he shooting at a moving vehicle? Why was he shooting at someone who was not a threat to him? Can only lead to someone to believe that it was in reckless disregard for the life of this person, an extreme disregard for the life of this person, leading me to believe that at the very least, this is murder in the second degree. I don't think it's murder in the first degree because I don't believe there's premeditation and deliberation, but I think that the conduct here certainly warrants the belief that this was an extreme disregard for the value of Miss Good's life. That is on the criminal side. In the criminal side. On the civil side, certainly is something that was excessive, unjustified. The law of the land under the Constitution, under the Fourth Amendment by the Supreme Court is provides that officers could only use deadly force when they're faced with an imminent threat of death or serious bodily injury. That's based upon the facts, based upon the position of the officer and the officer's reasonable belief. And here, again, because the officer was not under any threat of his safety, particularly not imminent threat of death or serious bodily injury, then I do believe that there's also civil liability here. Now, I think the broader question is that it's not up to me. I'm not the judge. I'm not the jury. But I think what's most interesting from a trial perspective is that this has been a very controversial shooting, a very controversial case. And unfortunately, it's boiling down to political beliefs, ideologies. People on the left are clearly saying it's a murder. People on the right are clearly saying it's a justified shooting in lawful self-defense. And this is exactly what happens in a jury trial. I mean, I've tried a lot of these cases on the civil side, and many of these cases fall on ideological lines. What do people believe? Do some people support law enforcement no matter what, which there are many out there, or do some actually believe that officers can make mistakes? And so, although I do believe it is a murder, I strongly believe that there will not be a criminal prosecution. That is almost guaranteed. And so I think what's left now is potentially a civil case brought by the family of Miss Good. But even then, it's going to be somewhat of a difficult case. And so I have my personal beliefs, but I also understand from experience and from trying many of these cases what could result in a civil trial.
Gotcha. So for me, when I first saw the footage, um, the first footage I saw was the one that was where you can see the ICE officer trying to open her door. So he's kind of blocking the view of the officer who actually did the shooting, um, slightly. So from off the bat on that one, I couldn't tell one way or the other what was going on. It was the footage from a distance, that was up higher, that had the officer in front, that made me side more on the ICE officer's potentially getting hit by the car. And politics aside on it, correct me if I'm wrong, but the I'm under the understanding that it's the perception of the officer that ultimately counts in court. Could it be reasonable for the officer to interpret a 4,500 pound vehicle potentially causing him death or harm? And we have the ability of hindsight where we can pause, rewind, record. Even his footage from his phone um, was showing her turning the vehicle away from away from him. So until I saw that, I thought maybe she was trying to hit him, but I wasn't sure on that point. Now I'm saying, okay, maybe she wasn't trying to hit him, but from his perspective, in a split second could he perceive that, right? So my question to you is, if this were to go to court and you were defending the family in this case, how do you, if I'm in the jury, how do you convince me that in that split second he acted recklessly, uh, even though it could be perceived that a 4,500 pound vehicle coming at you could harm you?
Right. And so you are correct that the standard is what the officer perceived from his perspective. There are several vantage points from where we could see this play out. I looked at this video from the back of the vehicle as it's driving away.
Mhm.
There's other footage, you're right, that is somewhat at a distance, which kind of shows the officer's body move quickly. And then the third video in question is the video from the officer's more perspective in terms of the one that he's holding,
Mhm.
showing more of his perspective. And so ultimately, it's going to be a jury's determination as to whether it was reasonable. And so if I am representing the family, I would argue that foremost, one of the considerations in the case is the officer's tactics, his conduct leading up to the shooting. And so one of the biggest factors I think that helps the family and helps Miss Good is that he put himself in that situation. He put himself in some way in harm's way. And so he could have very easily moved as he saw that vehicle trying to pull away. And so I know some folks may say, well, they were giving her lawful orders but at the same time, if he places himself in a situation which then he uses to say that was a factor or the reason why he used deadly force, he doesn't get to justify that force because he improperly placed himself in that situation. And so I think that's number one. How did he end up in that situation? Right? He put himself in harm's way. That's number one. With respect to whether he was actually subjected to a threat by that vehicle, I think he wasn't in the path to be struck by the vehicle. He was close. He was close, but he was never struck by that vehicle. In fact, I think there was a 3D analysis done by some sort of independent company, which shows that he was never struck by the vehicle. But then I understand the other perspective. Even if he wasn't struck, if he thought he was going to get struck,
Mhm.
whether that was reasonable or not. I think that's somewhat of the linchpin here because it's what he was perceiving at that time. Sure, we could very easily stop and play these videos. And in fact, the Supreme Court has said that we can't look at these things with the benefit of 2020 hindsight.
Yeah.
We're here in the comfort of our offices, stopping and playing. I understand that. But the video is the best evidence and it shows us exactly where he was and what path this vehicle was traveling prior to the shooting. And so it shows that he wasn't going to be struck by that vehicle. But again, I think that the strongest arguments are towards the second and third shots, that definitely in the second and third shots, he was already in the driver's side portion when he was discharging those shots. We know that there was one shot
Mhm.
that he was certainly in front, because there is a gunshot
To
that
the-
struck the front of the vehicle, and I think that's the first shot.
So that was one point that I brought up in discussions with people. That for me, I was like, I would say that if I had to pick out of the three shots, which one would it be justified? I would say the first one. But the other two is where I was finding it hard to justify those following two. But then um, it was an argument was placed to me that he could have been the second two could be justified in that there's other people in the vicinity, there's other ICE officers around. Um, so it could be justified as him trying to stop her from going and hitting somebody else. Is that how is that an argument? Um, is that a valid argument to you? Like separate from this situation and it being the ICE and whatnot. Uh, is it a valid argument that an officer shoot at a vehicle in general to stop it from ramming into other people potentially?
That could be a justification if there were other officers near him. Let's say he had a partner to his left, then that would be a valid argument. But here we know there were no officers, and I don't believe that was articulated by the officer himself in terms of, oh, I shot because I also believe that this person was going to harm one of my partners that was near me. And
Correct. I
so,
haven't heard that from
right,
ICE or
right.
DHS.
Right. So I just don't think the facts here support it. There is that is a possibility though in other different factual circumstances that yeah, if someone is going to use a vehicle to strike someone, then yeah, the officer can use deadly force in defense of self or defense of others when they are presented with an imminent threat or a deadly threat. And so the facts in this case just don't support that circumstance. I think here the main argument is, well, I was in harm's way and I needed to shoot to preserve my own life. And so I think the first shot, again, speaking objectively here, trying to be as objective as possible, I do think that first shot is more debatable in terms of whether it was lawful or not, but the second and third shots are just unforgivable. I mean, there was just no justification whatsoever for those second and third shots. And so now that leads us to two other relevant topics of discussion that come up in these cases. Number one is causation. So, okay, sir, you're saying that the second and third shots are unjustified. The autopsy reveals that it's only the first shot that actually struck her and killed her. The second and third
That's
shot,
gonna be my next question. What if the second
right,
two shots didn't hit her?
right. So if the second and third shots didn't hit her, then those arguments are out the window. Then the second and third shots are somewhat out of the picture. Because if the autopsy reveals that there was only one gunshot wound that entered in the front of her body, then that's likely the first shot. But
Mhm.
if there's other shots that entered the left side of her body and those were the deadly shots, then that's when those second and third shots come into the picture. But if we're only dealing with one shot here, which went in through the front of her body, then you can't even bring up, it would be pointless. The second and third shots are irrelevant because it didn't cause her death. Yeah, they were discharged, but what caused her death? And so we're gonna have to wait and see to figure out what the results of that autopsy are, to figure out, first of all, how many shots struck her and which shot struck her, and then also what is important is which one was the fatal, if one of them was, because sometimes it's a collective
Mhm.
shots that are the cause of death for exsanguination, excessive bleeding, or sometimes it's just one which hits a major artery. So that's going to be a big point of discussion. Number two is something that comes up fairly frequently in these cases, and it's called perception reaction time. And so what that means is that the humans, we don't perceive everything instantly as it occurs.
Mhm.
Sometimes there is a lag in terms of how we perceive things. And so one of the arguments that comes up fairly frequently in these cases is that, oh, well, yeah, sure. When you look at the video with the benefit of 2020 hindsight, you see those shots being discharged as she was driving away. But from the perception of the officer at the time, there was a lag in the perception of the threat no longer being there. And that's why those additional shots were being discharged as the vehicle was driving away. And so my response to that is, sure, that I agree, perception reaction, that is actually something scientific. How it's interpreted and how it's presented is up for debate, whether it's pseudoscience or not. But perception reaction, it's called human factors.
Hmm.
That's something that exists. It's a recognized science. But in this case, the officer had to actually move his gun as the vehicle was driving away to position it and aim at her as she was driving away. So I understand perception reaction in terms of, oh, you kept shooting, but your final shots were as the person was, let's say, falling down or no longer being a threat. But in this case, you see the officer actually moving his firearm and shooting as the vehicle was moving away. So he certainly was perceiving the vehicle moving away, and he was perceiving this person no longer being a threat.
Gotcha. So is it the for the basis of the law then, is it that the justification for a shooting has to be the same throughout the whole process of the shooting? Meaning, uh, even if it was justified at the beginning, um, it has there's requirements for it to continue to be justified throughout.
Well, let me say this. Every shot discharged from a firearm has to have its own independent justification. And so each shot, there has to be a justification for the shot. I know it's a little bit difficult parsing it out because there is some training, just based upon my experience of doing these cases, that police officers are trained to shoot, for example, center mass.
Mhm.
Sometimes I get asked, well, how come they didn't shoot the person's leg? Well, their training is they have to shoot center mass towards the torso area. And sometimes they're also trained that they could shoot multiple shots in a sequence. And so, but at the same time, this is something that requires independent justification for each shot. Each shot, they have to have a justification. Sometimes on the plaintiff side, when we represent decedents, we say, oh, well, they should have stopped and they should have reassessed to determine whether it was still justified. But admittedly, it is a rapidly evolving situation. You know, sometimes the officer can't stop and figure out, oh, should I continue shooting or not? They shoot when they perceive a threat and they shoot until they no longer perceive the threat. That's essentially what these officers typically testify to.
Gotcha. Now, the other question I had, because I asked this of our last guest on this topic, um, they've come out and talked about the officer's previous encounter with somebody who was in their vehicle and dragged him 300 feet, and he had stitches and all that stuff. I actually remember seeing that story on the news last summer or last year when it came out. So, is it an argument to say that past occurrences or run-ins with vehicles and somebody trying to be detained out of said vehicle um, could play a part in the justification of why he reacted so aggressively, given his past encounter with somebody who refused to get out of the vehicle?
Yeah, that's a tough call. I am aware of that history. And the reason why I say it's a tough call because on the plaintiff side, I likely would move to exclude that as prejudicial, more prejudicial than probative, or more prejudicial than relevant, because I wouldn't want a jury having information that this officer was involved in a prior encounter because it just creates a case within a case. Then I'm going to have to try to explain, oh, well, was the officer justified or not? You see, or you see, this is an officer that is prone to getting involved in these dangerous situations. It just creates too much of a case within the case for it to be admissible, from my perspective, in
Mhm.
our case, in this case. So that would certainly be the subject of a motion to eliminate. And so a judge could potentially exclude that information because, again, it creates a case within a case. But let's say it is admissible. Let's say it is admissible within the trial. The defense, of course, is going to say, look, this is an officer who's putting his life on the line. He was already involved in a prior circumstance, which was very deadly, and he knows how deadly these situations can become, and that's the reason why he used deadly force. And so he didn't overreact. He actually has experienced this before, and he was trying to stop this. He was trying to stop him being dragged or being run over by this vehicle. That's what the defense is going to say. That's what the officer is going to say. If this evidence comes in, which I wouldn't want it to come in, I would argue this is an officer who is prone to subject himself to dangerous situations. This is an officer who puts himself in dangerous situations. And so just because this officer doesn't care about safety, doesn't care about the safety of the public, doesn't mean that my client or this innocent woman should have been killed. That's an even greater reason why this officer should have used better tactics, should have positioned himself better, knowing that if he gets too close to a vehicle, he could be dragged. But instead, he put himself in danger. He caused this situation, and he's the one that caused this shooting. So
Yeah.
that I did hear about that information. I just think I don't know how admissible it would be,
Mhm.
but I think it does help. I think it does help the defense. I think that type of evidence would help the officer in terms of, well, look, he has been through this before, and that's the reason why he reacted the way he reacted. But at the same time, the standard, at least on the civil side, is what a reasonable officer under same or similar circumstances would do. It's called a reasonable officer standard in terms of
Yeah.
how you assess the conduct of these officers.
Gotcha. So the other angle that I pointed that out to somebody and gave that both sides of that argument. And when you watch the video, he's if this is the vehicle, he's standing over here when they tell her to get out, and then she backs up the vehicle, and from being here to here is what puts him in front of it. Um, so in that case, if they were to say he didn't position himself in front of the vehicle, she positioned the vehicle to flee, which whether she was intending to line it up with the officer or not, it put him in that position. Um, what accountability on the civil side, and then it's not the criminal case, but if this is the family's argument in court, how does the family argue um against whatever actions that Miss Good was taking leading up to the shooting, whether it be obstructing or ignoring the officers or positioning her car in a way that the officer deemed a threat? Like, what amount of responsibility does her actions take in all that?
Well, if this were a civil case, there likely would be a negligence claim included in the lawsuit. And here, at least here in California, we have comparative negligence,
Hmm.
where the jury can determine if the decedent was negligent, and if so, and also if their negligence was a substantial factor, and if so, what percentage did they allocate to the decedent? I've had several cases with comparative negligence. And so that is a possibility for the jury to assign in terms of if they find that she was negligent. With respect to the substance of those points, foremost, it's unclear if these officers have jurisdictional power to enforce an alleged impeding allegation. So I think there's been an allegation against Ms. Good that she was obstructing or impeding the enforcement of the immigration enforcement of these officers. I'm not sure whether they could even enforce those laws. They are there to apprehend alleged folks who are here illegally. I'm not sure whether they even have that jurisdiction. Therefore, I'm not sure whether they were giving her a lawful order, whether she was actually required to comply with that. Let's say she was required to comply. Let's say she actually was required to comply. I think I don't know enough of what led up to the shooting itself, or to that interaction where she was driving off. But I know she was there saying, "Hey, I'm not mad at you," and
It's
signaling, yeah, signaling that, look, I'm not here to cause you harm. If she was, let's say, involved in a crime,
mhm.
let's say she had just robbed a bank, or let's say she had just shot someone, I would get it, because this is a criminal, an alleged criminal, who is trying to get away because they just committed a heinous act, or they just committed a crime. I get that. Some folks, they want to get away for on any means possible. They want to get away under any circumstance. Some folks have a criminal history and they don't want to go back to jail. We don't have any information that this woman had a criminal history, that this woman had committed any crime. So the desperation or the intent to flee the scene under any means necessary weren't there. And so, in fact, she said, "Look, I'm not mad at you." And so that is further information for the officers to say, "Oh, this person is not trying to cause me harm. She's not desperate. She's just driving away because she's not listening to us." With respect to the positioning, I think the officer still had enough time to move out of the way. It didn't seem to me that he was engaging in any acts to try to move out of the way. In fact, it looked to me like he was trying to get in the way. I know it was somewhat of a rapidly evolving situation. It happened over the course of several seconds, but as soon as she turned that wheel, I would have stepped to the right. I mean, I would have stepped to the right. I think what goes on in these officers' minds is, look, we're officers, we're giving you orders. I'm going to step in front of this vehicle because you should stop, and I'm the law. And so I think that's what goes on in their head. But at the same time, you're risking it. You're risking that someone is going to comply with you merely because you're an officer, at the risk of potentially being in harm's way. And so I think he had enough time to get out of the way of that vehicle, particularly when it turned. He could have very easily stepped to the right. He had enough time to step near the vehicle. In fact, I think he stepped closer to the vehicle. And so he had enough time to step out of the way. He just didn't. And so I think he definitely could have gotten out of harm's way, but he didn't.
Yeah, so one interview I saw with a witness who was at the scene. I'm not sure what her relationship is to the Miss Good or anybody who was there protesting. But she did not seem, she seemed to be on Miss Good's side as far as all the people that were there. She was saying that the reason that ICE targeted her vehicle specifically, because when you watch the longer clip of the scene, there was a vehicle that left prior to Miss Good's vehicle, and then she stopped when a vehicle went in front of her and drove off, and she was waving the ICE officer's truck over to pass by. That the reason that they didn't just pass her by and they actually got out to address her was because she was leading some sort of caravan. And then a video came out of her for 3 minutes, like beeping her horn and blowing whistles. And that's why her wife was outside of the vehicle. Would any of that be admissible in court to say, look, 3 minutes before this, she was causing a ruckus and impeding their work by trying to announce ICE's presence while they're trying to arrest a subset.
I believe it would be admissible. And in fact, that's something potentially that I would bring up on the plaintiff side. Again, this leads more towards her being an average day citizen. She wasn't fleeing the scene of a crime. She wasn't fleeing from a crime that she had just committed. She had not committed a crime. She was engaged in lawful First Amendment activity. The First Amendment allows this type of activity. The First Amendment allows protests. The First Amendment allows individuals to record and document ICE. And the First Amendment allows folks to monitor the activities of ICE. I think the First Amendment encourages people to monitor law enforcement to see what they're doing out in the public, so long as they're not impeding and interfering with their lawful enforcement. And it's important to say lawful enforcement, because if you see a cop, if you're walking down the street and you see a cop punching someone who's innocent, you could actually defend that person and get the officer off that person. Sure, you don't know what happened, but and I probably wouldn't recommend that because
Yeah.
there's always there's
I
always a
I
lot of
definitely would not recommend.
yeah.
I call other officers over. But
Yeah. I would not recommend that because you don't know what happened. Perhaps that person is a wanted criminal or something. I don't know. All that to say is that, yeah, the First Amendment allows folks to engage in this activity. And so, whether you like it or not, whether you think it's a productive use of someone's time or not, I've heard people saying, "Oh, well, didn't she have kids? What was she doing out monitoring ICE?" And so, I think it's incumbent on people to act as a check on law enforcement, so long as you're respecting their space and you're not interfering. You're allowed to do that. That's your constitutional right. So I think it further shows her intentions. Again, this is not a person who was trying to flee the scene of a crime. This is not someone who had just committed a crime. They were engaging in First Amendment activity. If she was, again, had just engaged in a crime, I would get it. The officers thinking, oh, this person is desperate. They're going to do anything to get away because they just committed a crime. They're going to go to jail. But this is a person who clearly is a protester or clearly is there to be as a check on ICE. And to me, if I'm an officer, that means that this person is harmless. This person is not trying to cause me harm. She had not threatened the officers in any way. She had not done anything threatening prior to that. She had not caused them harm in any way prior to that. So again, that further shows that she didn't have the intention. It was inferred that she did not have the intention to cause harm to this officer.
so in respect to what can be brought in and can't be brought into court to argue, um, the according to DHS and ICE, in the over the past year, there's been over 100 vehicle rammings from protesters agitating ICE. Whether when they now, of course, when they say vehicle rammings, that can be as simple as a full-on speed or a tap or a fender bender. So there's a scale at for what is qualifying as a vehicle ramming. But could that could past protesters' actions justify the perceive could or elevate the perceived threat of a new protester who they may never have interacted with, but a pattern of past protesters uh, warp their perception of what she's doing. Because granted, she was just there making a big ruckus with her horn, First Amendment rights to be out there and yelling and doing whatever she wants to do. But on the perspective of the officers who have interacted with protesters on a daily basis and have had these 100 vehicle rammings and other violence with protesters. Granted, Miss Good has never been uh, alleged to have done any of these things. Could that be used as an argument to justify their perception of Miss Good?
I would certainly move to exclude that at trial if I were representing the family. I can't guarantee that a judge would exclude it, but I think a judge would likely exclude something like that. And for example, I have certain cases where the officer shot someone shot someone else a few months before the current case, or shot someone else a few months after. And yeah, that's something I would want to bring in to show that this officer has a propensity. It's
Mhm.
it's improper character evidence, right? But I would try to bring it to show that look, this person has a bias, he has an intent, there's a lack of mistake or whatever 404B under the federal rules of evidence uh, type of argument I can make. But I just don't know how admissible that would be because what judges try to do is they prevent a case within a case because sure you could refer to these other instances where protesters may have gotten out of hand, but if you're making that assertion, I would try to challenge that if I'm the plaintiff's attorney in terms of, well, I mean, did were these officers truly harmed? Was anyone ever killed? How fast was the vehicle moving and things of that sort. And
Hmm.
so I just don't know how admissible that would be. And secondly,
That,
we also don't know what the officer was thinking. We know he was involved in a prior instance, but
mhm.
we don't know what his justification for shooting was. And so I think what it boils down to is what reasons he gives in terms of why he shot. And
Yeah.
so the cases that I do at the state level
Mhm.
against local police departments and local counties, and sometimes even the state itself, these officers, before they give a statement, they meet with attorneys. And uh, these attorneys, they do these cases fairly frequently. And frankly, they feed these officers lines in terms of what to say and how to articulate it. And so that perhaps will be a justification. We just don't know.
Mhm.
We know that there's an investigation ongoing and we don't know what the officer is going to say, but it all boils down to what the officer was thinking, what he was thinking at the time he shot.
So where would you say is the line between a person's First Amendment right to protest and check our law enforcement and federal agencies and impediment? Um, if, for example, if I see a group of police officers going down the street and they're sneaking behind somebody, and I see that that person that they're going after doesn't see the police officer is about to pounce on them, uh, and I yell out, "Hey, Tom, it's the police!" and Tom runs away and gets away. Would I be in violation of any laws, or is that First Amendment protect me to telling Tom, "Hey, the police are about to arrest you"?
Right. So now we're talking about, in your circumstance, speech alone. And so I do believe that that should be First Amendment protected activity. I have tried some resisting and obstructing law enforcement cases, criminal cases too. And so the cases that I see are more when the person is being arrested, him or herself,
Mhm.
and what they are doing to impede or to obstruct that arrest. And so in your factual scenario, I don't believe there would be liability because the person is just engaging in speech. Whereas if someone were to engage in a physical act, let's say standing in front of the ICE officer, that's a little bit more debatable. If you're using force, such as grabbing a person who's being arrested by ICE, then that's certainly obstructing. And so I think just speech alone, that's more debatable in terms of whether that would be actionable.
Mhm.
But it just depends on additional circumstances in terms of what the person knew, and in terms of the person who's the subject of the arrest, and whether it actually caused the person to flee, or whether it actually did interfere with ICE's enforcement. Whether we wouldn't know that because it
Yeah,
would be a question to the person who ran. Why did you run? Did you see ICE beforehand, or was it solely because of what this person said? And so
yeah,
I just, that's a little bit more debatable when it's just speech alone.
yeah. I do believe that ICE did get their guy that day. He was I believe they were arresting somebody for, I don't know if he was I believe it was either domestic violence or rape or something like that, that they claimed the gentleman they were arresting therefore was alleged to have done. My question then is, where does it become aiding and abetting? Because I've seen, like, we've all grown up watching episodes of Forensic Files or the First 48, and like the family, they'll call like the brother or the sister or the mom and say, "Hey, if so and so is there and you're not telling us, you can be charged." Um, what did that not? I've never seen somebody get charged on any of these live police shows for that, but is that not, are they bluffing in that case? Because would that not be compelled speech, which is part of your uh the Fifth Amendment? You're not compelled to say anything, and you are also allowed to speak. So both the right to speak and not speak. Where does it become aiding and abetting to either not say or to say to somebody that the police are coming?
Yeah, and so I think for aiding and abetting, that's before a an alleged crime occurs. And so assisting in a crime, if a crime has already occurred, and let's say someone is hiding from the police, then that would be accessory after the fact, doing something to assist that person um, in completing that crime or carrying out that crime. And so I think with respect to using speech to assist folks who are evading law enforcement, I think it boils down to what that person knows, what that person knows in terms of when they're using speech. And secondly, here we're dealing with immigration enforcement. To a large extent, it's civil. And so it's a civil violation or a quasi-civil violation. So in order for it to be aiding and abetting or accessory after the fact, it has to be a criminal offense. And so I think it just boils down to what the person knows, what is the other person accused of,
Mhm.
and in terms of what they specifically do with respect to their actions. Because speech alone, again, is not sufficient to justify liability in certain circumstances.
Gotcha. So at the at the end of all this, right? Um, you being a civil rights attorney, you've gone through so many cases in your career dealing with law enforcement and excessive force. What type of training um, do you know that they have, or do you feel they should have to prevent situations like this happening again? Whether he was justified or not in the shooting, how can we work in a positive direction to keep something like this from happening again?
Well, the reports have been that ICE agents are not receiving adequate training. I mean, I'm not 100% clear as to what the training is now, but I've heard it's just a few weeks now. They're just enlisting folks and then putting them out on the field, which is an alarming trend. I mean, even police officers, 6 months is the standard training. I don't think that's enough because of just the responsibilities and duties that they have. So I think certainly there should be more training in this regard in terms of how to deal with these circumstances. But I think also tempering the use of deadly force. I mean, there's been an alarming rise of the use of deadly force by officers in this country. I mean, people get shot by police all the time. Sure, people may argue that, oh, well, because people aren't complying in their threats. But at the same time, just because someone is not complying and potentially a threat, that doesn't mean officers could shoot and kill someone. It's they have to have what's called a reverence for the value of human life. They have to revere the value of life, even if they don't like the person, even if they don't agree with what the person is doing. These officers have to apply the law equally. It has to be equal protection under the law. And so officers should have more reverence and understanding that, look, once you discharge that weapon, you can't take the bullet back. You might kill someone.
Mhm.
And so I think it's easy, again, it's easy for us to just sit here and judge their actions, but at the same time, just tempering that use of force could save someone's life, and also preventing these folks from being in dangerous circumstances by moving out of the way or by maybe de-escalating a situation in terms of using more efforts to lessen the intensity of a situation, I think is a way forward in terms of preventing something like this from happening again.
Gotcha. Yeah, so 100% on the training. I think that a few weeks of training to deal with such a high pressure job is not a good idea. Granted, I don't know what positions they're put into out of that training. I don't know what level of responsibility somebody on the force who's only been there for a month or two would have. You know, the officer in question um, apparently had deployed to Iraq. He's been an ICE agent for many years. I think his career spans about 15 or so years. So, as far as training, that wouldn't have affected him. But yes, on the grounds of better training for all ICE officers involved, I 100% agree that a few weeks for any law enforcement or job that allows you to carry a weapon is not uh, a good idea unless they had some sort of military or police training prior to that that would compensate. Um, on the What would be your advice for the uh, the protesters out there or people that you've represented? What is your advice that you give them that doesn't take away their fundamental right to protest and stand up for what they believe in, but also puts them in uh, safer positions when dealing with either police or federal agents?
Well, my advice has always been and continues to be to engage in protests, engage in First Amendment activity, engage in what you do safely. Do it as safely as possible and as peacefully as possible. I mean, no one wins when these situations are escalated. People lose their lives, people are in danger potentially, and it's just that's my advice is always to do this as peacefully as possible. Now, eh, I I don't take the position that I dictate how people should protest. I mean, I think it should be as peacefully as possible, and I always tell folks do this as peacefully as possible. Don't engage in something that could cause you to be in danger. And in fact, if you see something getting dicey or dangerous, I would remove myself from the situation because you never know. You be careful who you associate with. Some people are provocateurs, or some people are plants from whoever, and they're not there for your interests. They're not there for the interests of the overall good of folks. They're there to cause havoc, cause chaos, and you don't want to be in that situation. And so that's always my advice. Do this peacefully, and if things get out of control, get yourself out of that situation, and also be careful who you associate yourself with. Now, that's my advice.
Mhm.
Some people may look at me and say, "Well, look, you're coming from a position of privilege." Of course, you're going to say this. You're in your cozy office representing folks, and you're not out on the street doing the real work. And so, who are you to tell me what to do? I'm just calling it from a legal perspective in terms of what to do to avoid being in trouble and what to do to avoid being in danger. Now, is that the right way to protest legally? I think so, yes. Whether is it an effective way? I don't know. I'm not a protester. I am an activist, but some folks may disagree with my activism. They may think it's too tempered. I know there are some folks who are more who push the boundaries more. But if you're going to push the boundaries, I think at the end of the day, you have to just make sure that you are cognizant of the safety of everyone involved because you don't want to be in these situations.
Absolutely. Christian, thank you so much for joining us today. This is a very insightful conversation. Thank you for giving us both sides of the equation from the inside the courtroom perspective. Is there any final words that you'd like to share with the audience before we go out?
Sure. Well, you asked for my initial take on this case. I think it's a tragic case. Miss Good shouldn't have been killed. I still stand by my position that it is a murder. But when you look at murder, you have to take a look at what type of murder. Do I think it's a first degree premeditated, deliberated murder? No, I don't think so. I don't think this officer had the plan to kill this woman. But I do think particularly in some jurisdictions, that this is second degree. And second degree, yeah, you have to intend to kill, but you don't need premeditation or deliberation, at least in California. You can be on the hook for second degree murder if your conduct kills someone and you do it with extreme disregard for the safety of that person. And so, again, it's going to boil down to what the autopsy says and the trajectories in terms of which shots actually killed this woman. But I do think, at the very least, that the second and third shots warrant and justify this as a murder because of just the unnecessariness of these second and third shots in terms of there being no justification for it. I mean, the car was driving out of the way of this officer for the second and third shot. And I get it, it was rapidly evolving, but at the same time, this is a firearm. This is a firearm that could kill someone, and it did in this circumstance. And I think that it's just unnecessary and unfortunate. Now, the bigger question is whether there will be a criminal filing. I believe there is a 5% chance that this gets filed, maybe even less, as a criminal case. I do not believe there will be a criminal filing for this case. I don't. And so even if it is filed, though, even if it is filed, whether a jury would convict this officer, even if this case gets filed criminally, I do not believe there will be a prosecution. And so that's the reason why I don't believe it will be filed. Because when the prosecutors decide whether to file a case or not, the first consideration is whether they could prove their case beyond a reasonable doubt, right? And so even if this case gets filed, I certainly do not believe that a jury will convict. Now, when I call it a murder, that's my perspective, that's my belief, my professional take on it in terms of whether there will be a criminal filing is that it won't. And then even if there is, there won't be a criminal conviction. Certainly not. That's just my perspective and my experience and what the trends that I see. I live in Los Angeles. And even here in Los Angeles, the criminal charges against a police officer are rare. And even when they do proceed, some of these cases have resulted in either mistrials or acquittals. And so just based upon how the world perceives officers, I support officers. I support law enforcement. I'm not about defund the police. I'm not about abolishing the police. But just how the officers are perceived in society, it permeates throughout a jury, and I just don't believe a jury will convict this officer criminally.
Gotcha.
But we also talked about civilly. Civilly, where would this go? And I do believe that in a civil case, because the standard is preponderance of the evidence, whether something is more likely true than not true, whether this shooting was excessive, whether it's more probably true than not true that this shooting was excessive is what will be the question. I do believe that a jury could find the officer civilly liable for excessive force just based upon the trajectory of the shooting, him putting himself in harm's way. But again, it's going to boil down to which shot was the deadly shot. If the first shot was the deadly shot, and let's say it was the only shot that struck her, it's going to be a much, much harder case. But let's say that we see the autopsy report and it's a shot coming in from the left side of her body, which only struck her and which caused her death, then it's a much stronger case for the family. And so the science matters, the forensics matter. And so I think we still need to figure out a little bit more in terms of these details. But I think in a civil case that the odds of prevailing are a little bit higher. And I do think at the very least the shooting is excessive. And so I think the family does have a case certainly at the civil level.
Excellent. Thank you so much, Christian, for joining us today. Next time we gotta get you down to Miami to talk about the rest of your illustrious career as a criminal defense attorney back in the studio.
Sounds good. I appreciate it.
All right,
man.
Thank you so much for being with us today.
Thank you for joining us on this special segment of Inside Trial Minds. Thank you to our guest, Christian Contreras. And remember, stay safe, stay focused, and we'll see you next time.